Munyeri Levi.
Present, my lord.
The Honorable Senator Dan Manzo.
Present, your lordship.
My Lord, on an ordinary day, the majority of the senators and the MPs will have been here, but the minority does not deter the cause. We also have Abana Mango.
Present, your lordship.
We have Ramadan Abubakar.
Present, my lord.
And we have Madam Rebecca Omwenga.
Present, my lord.
My lord, we are the ones who moved the court, so we will speak first. It is our claim.
May I please, I am just again, I don't know, I'm coming to say good morning, or we all say good morning. I will make an application very respectfully. That you join Kito this area.
So if you want to speak on it,
for many years, my lord,
it's okay.
In the country for constitutional and for independent so now, enjoys itself from time to time in cases to the High Court. And I've never been a problem or any issue for any court or any judge joining the Georgia City at all. But I may say this, Your Honor. We Kenyans are what we are at the moment. And among nations of the international community because of upholding the rule of law and respecting constitution. If I may.
Your Counsel, I really don't want to cut it short because
If I can, I would say it's more than
so can you make it short?
yeah, Your Honor, with that injunction, I will go any further. If you didn't join it, it will disappear, and that will
My Lord, that's why I'd asked that you allow us to speak first, because we're the ones who move the code. Some of the things we'll say may...
I saw you have an application in 2017.
Yes.
Where you want a constitution. There's an application from your end.
Yes, we filed an application to that effect.
Today you appeared before Justice Smith.
On that application?
Yes.
Yes.
Before Justice Smith, who placed the matter
Before you. Yes.
So you are the people to tell me why I am here.
Very well.
Who asked for this matter to be mentioned? Was it your application or was it the rest of the
My Lord, I'd like to respond to you, and I kindly request my landing to take a seat.
Okay.
Yeah, let's find out who went before Justice Smith yesterday for the member to direct the matter be mentioned this morning.
It is us.
May it please you, my Lord.
And then after that, I went to the CPS and I found there was also an application which I gave direction that I should be giving it to the society.
Okay.
May it please you, my lord, I forgot to put on record Mr. Bita and Mr. Mutinda from the Office of the Attorney General. My lord, when parties appeared before Justice Muita yesterday morning, we made an application, requested the judge to allow us to produce before the court the Deputy Inspector General, as was directed by your lordship on the 13th. And we did that because the 7 days window that was given was going to lapse today. And for that reason, Justice Muita directed us to appear before you this morning for the matter to be mentioned. For the sole reason that this mention is for purposes of producing the Inspector General before the court as directed. I wouldn't have said the next sentence because I thought it was going to be easy, but I'm going to do so. That this is post-sentence appearance. And for that reason, the petitioners are not properly before you, and even if they are, they do not have audience. Your order, my lord, was self-executing. It would have been operational whether or not the parties were before you. Thank you. And if you will rule on that, as a tutelary head of the bar, I think I have the right to address you first. This is not only as a matter of practice, but it is also pronounced in the Attorney General's Act. So I will let you rule accordingly.
The petitioners are before the court. They have a right to address the court on any matter that is before it. They cannot be guarded. Okay, which application are we dealing with?
We are dealing with the application to...
We are looking at
appearance
of the
before the court.
Inspector General of Police. Eh?
Yes.
Okay, I think we should allow, let me hear you, and then I will hear the Law Society, and then after that we will see the way forward.
What about me, my lord?
Dr. Amino, you see, because of your age, I have always told you that I really respect you. And yes, so kindly, would you kindly do a formal application? Yes, I will request you kindly do a formal application. I didn't want to address that first because you see now the proceedings we have today, you can see the kind of matters we have. We must have to deal with those issues first. Then we can deal with other applications later. It is not possible for us to deal with all these applications that might arise now. So I will request that you go and do a formal application.
I file a formal application.
Yeah, serve it to them.
I'm not opposed to doing that.
Yes.
The only thing I would like to point out respectfully that your brothers and sisters have been admitting kituo cha sheria. It's not me really, kituo cha sheria.
I have not refused to admit it.
Without a formal application.
Don't worry, I have not refused to admit kituo cha sheria. Only go and do a formal application and I'll be able to look at it.
And then by the time I arrive, the court will have adjourned.
I'll just go do it, post it, I'll give directions online. I will give my directions online. You don't have to come. Yes. Right, thank you. Thank you so much, Dr.
May it please you, my lord, in this matter, the Attorney General was initially on record for the respondents, in particular, regarding the orders made initially on the 23rd of August 2024 and the 13th of September 2024. Then Mr. Miller and Mr. Ogola were representing the first respondent. And they are now on record. They were. Then the first respondent was represented by the Attorney General, but today Mr. Ogola and Mr. Miller are now here on record for Mr. Masengeli because content proceedings have now been cancelled. Also attending court today is Deputy Inspector General of Police, Mr. Gilbert Masengeli. He does so in compliance with the order of court issued on the 13th of September 2024. And this is within the time span prescribed by your Lordship in the order your Lordship had generously and graciously directed. Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend this sentence for 7 days only. The Acting Inspector General of Police can redeem himself and comply by availing issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. End of quote. My Lord, the court summons in question and bespoken by your Lordship in that order, and to which the first respondent was to answer, had been made on the 26th of August 2024, in which your Lordship rendered as follows. That summons to issue to the first respondent to appear in court on the next mention to explain why the habeas corpus orders issued by the court were not complied with. The matter was fixed for mention on 3rd of September 2024. My Lord, it is our first duty to explain the reasons why hitherto Mr. Masengeli has been unable to make a personal appearance in court in answer to the court summons. This inability has been misrepresented by both the petitioners and certain press reports. It has widely, but incorrect, been alleged that the summons thereby issued have been either ignored or defied.
Are you explaining that on this one?
No, I'm not. I'm talking generally.
All right.
Oh, she's reading a speech.
Just a minute. Thank you, Madam.
Thank you, my Lord. My Lord, I'm saying that because the misrepresentation and the miscorrections not only affect the respondent, Mr. Masengeli, as an individual, but they also affect the executive and other branches of government. So it is not just a personal matter. It has widely but incorrect been alleged that the summons thereby issued have been either ignored or defied, reportedly as an act of arrogant disregard for this honorable court's authority and its constitutional mandate. Nothing could be further from the truth, and regrettably, it has not been possible to proffer a full explanation of the situation until now. My Lord, on each occasion when the personal attendance in court by Mr. Masengeli was required, he was disabled from doing so by pressing exigencies of duty out of Nairobi, and on each such instance, discreet attempts were made to communicate these difficulties to court without having to disclose delicate and sensitive operational detail which were of national security nature. When the orders of 26th of August 2024 were served on the first respondent on the 29th of August, Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty when the orders of 26th of August 2024 were served on the first respondent on the 29th of August. Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty. As is now common public knowledge, that region suffers from a very tenuous security situation. Mr. Masengeli and other national security operatives had traveled to attend to urgent security concerns. Accordingly, the Director of Legal of the National Police Service, Mr. Charles Otiende, was detailed to attend court at the next mention of the matter on the 3rd of September 2024. He was to inform the court of the circumstances under which, thus far, the first respondent had been incapable or disabled from complying substantively with the habeas corpus application. However, the official was seized with information which would reply to the court's questions relating to the habeas corpus. The instructions to Mr. Otiende were issued on the understanding that, on a reasonable reading and construction of the order of 26th of August 2024, the first respondent could be represented in court by any competent officer or official. Mr. Masengeli had also been advised that the court proceedings on the 3rd of September were scheduled to be virtual and that the representative of the first respondent could attend virtually. My Lord, in a further effort to assist the court in its inquiry, the respondents filed an affidavit on the 4th of September 2024 in reply to the ones filed by the petitioners. In his affidavit, he set out an account of how the first respondent received a missing persons report and the ongoing investigation measures that it was undertaking to trace the whereabouts of the missing individuals. My Lord, when the matter was again mentioned in court on the 5th of September, Mr. Masengeli was still engaged in the security operations in the coast region. He provided an affidavit and affidavit evidence to this effect as Annexure GM2. This was the relevant police signal with OB numbers indicating the brutal murder of 4 men in Taita Tana River County, presumably as a retaliatory attack in an ongoing clan dispute which was spiraling out of control. As a result, the first respondent was represented in court by the aforementioned counsel, Mr. Otiende. Mr. Simon Kirui, the officer in charge of Directorate of Criminal Investigations, Kitengela, also attended, and Mr. Joseph Indeke, the investigating officer in the subject matter of the disappearance, also attended. After the court proceedings of the 5th of September, it was understood that Mr. Masengeli's personal attendance in court was required on 9th of September.
On which date? 5th?
After the 5th, yeah? Mm-hmm. The affidavit was filed on the 4th, but on the 5th it was clear that Mr. Masengeli's personal attendance in court was required on September 9 or 9th of September. However, in the interim, the security situation had deteriorated considerably and increased in its complexity. As demonstrated by annexures to Mr. Masengeli's affidavit marked GM3. It is a police signal, complete with OB numbers, indicating an Al-Shabaab attack on one of the police stations in Wajir County, which event demanded Mr. Masengeli's, with other senior security personnel, personal attendance. My Lord, national security is the protection against internal and external threats to Kenya's territory and territorial integrity and sovereignty. It's the protection of Kenya and its people, their rights, freedom, property, peace, stability, and prosperity, and other national interests, as enshrined in Article 238, 239 of the Constitution. All institutions of and in the Republic exist under the aegis of a secure sovereign military. The primary object of any national security organ and security system, including the National Police Service, is to promote and guarantee national security in accordance with the principles mentioned in Article 238(2) of the Constitution. The fundamental nature of national security cannot therefore be overstated. But it is also equally fundamental and a fundamental constitutional principle that the national security organs are subordinate to civilian authority, Article 239(5). That is why, despite the excruciating and heavy security demand upon him at the material time, Mr. Masengeli nonetheless saw it fit that the DIG, Mr. Eliud Lagat, attends court on the 9th of September, and he attended. For the first respondent, he wasn't given audience, and it now transpires that, given the specificity of the orders issued by the court latterly, and quite understandably, Mr. Lagat could not and did not have audience before the court. When the court sentenced Mr. Masengeli on the 13th of September 2024 for contempt of court, he was still in Marsabit County coordinating security operations. Annexure 4, G4, in his affidavit, is a police signal with OB numbers indicating that an unknown number of armed militia had attacked a bus.
When the court sentenced him, where was he?
Sorry?
Where was he at the time of the sentence?
Or when the court sentenced on the 13th of September, he was still in Marsabit County, my Lord, coordinating security operations. And that is evidenced by Annexure 4, G4, in his affidavit, which is a police signal. It has OB numbers, indicating that an unknown number of armed militia had attacked a bus service vehicle registration, KCX 039N, and had sprayed it with bullets with catastrophic results. My Lord, the main objective in setting out the foregoing facts in extenso is not to excuse the failure by Mr. Masengeli to attend court. It is hoped, however, my Lord, that it will demonstrate that he did not deliberately degenerate this honorable court, as has been characterized by counsel for the petitioners and others. Nor do the facts show that he did not recognize the authority of this honorable court. The apology which he wishes to tender and duly tenders to this honorable court today is without reserve. It was clearly tendered earlier in his affidavit of 12 September 2024, and it is repeated here. In my humble submission, my Lord, I plead with this Honorable Court to take into account the extenuating circumstances narrated by Mr. Masengeli in his affidavit, my Lord, this is not just a simple instance of clash of loyalties. It is rather a case of a security official caught up in the horns of a dilemma, whilst in the midst of a serious and delicate security emergency. It is easy in such circumstances for one, perhaps without deliberate intention, but instinctively, to gravitate towards national security operations over personal tribulations. My Lord, it is on this basis that we plead with you to exercise your judicial discretion to incline towards grace. My Lord, may you temper justice with mercy in the realization that the actions of Mr. Masengeli in his case were not sheer or brazen, but of loyalty of a citizen gone weary in the course of doing his best in a bad situation to serve two pressing and seemingly equally demanding solemn duties. I further plead with you to take into account the contemner's promise to file regularly a progress report on the investigations regarding the missing persons or any update therefrom. Thank you, my Lord. Thank you for giving me audience. The last time I appeared before you, it was in a different capacity. I'm grateful you gave me that audience. Thank you, and I'm obliged.
Mr. Mir.
Yes, my Lord. I wish to inform the court that Mr. Masengeli is present and ready to take the stand to explain himself, as was directed by the court. I am praying that he be sworn in so that we can lead him through the process of complying with the court's order, my Lord.
I will go to the petitioners now. I will also give you time to address the court.
My Lord, I've listened to what the Attorney General has said. 2 points were outstanding. She said that there were discreet attempts to reach the court to explain serious matters of national security. Why is discreet attempts? What the court makes out of those statements, we leave it to the court. But from our side, we find it extremely deplorable that the office of the Attorney General will admit that there was interference with the judge insofar as this matter is concerned. We'll leave it at that for now. Number 2, the Honorable Attorney General.
My Lord, I wish to take objection. Kindly, I wish to take objection.
What is the objection?
That is a very major accusation. please take your seat. That is very major accusation. And he has to put on record where I said that there was effort, or where I was admitting that the judge was interfered with as the Attorney General. And from my statement, where I admitted that there was interference with the judge.
So, Mr. Nelson, did you?
My Lord, number two, I'm old enough not to be distracted from my life.
Kindly respond to that. It is important. You have made a very serious
She has a written speech where she said there were discreet attempts to reach the court to explain the delicate
let him be
nature.
given a dictionary to define the word attempt.
Okay. What did you hear from the counsel for the 8th?
No, I will not withdraw. We are on live camera. They will play that clip if she says she didn't say it. But I've finished what I was saying on issue number one. Let me go to number two. You can go back to your note. She said there were discreet attempts.
Attempts.
Yes. Please respect your office. It's
Well, I can't see it, but
okay. Watacheza kwa Citizen jioni will hear. So, number.
I think Mr. Habib, you know, we are. This is a court of law. The public is watching.
Yes.
Kindly let that. As a judge, I can say that. Well, maybe it has missed. I have missed it, but I don't think I have heard that.
Okay, the court may not have heard.
I may not have heard that.
But we had it.
And if there were discrete attempts, then I don't know where they were being made.
It's okay, my Lord.
Yeah.
Could you allow me to go to number two?
Let's proceed.
Yeah, I'm not apologizing, friends. We're dealing with a serious enterprise here.
Since you are reading a statement,
Yes.
Is it in your statement that you are making discrete attempts to approach the court or something?
Hello.
What is it that you said so that it is clear for the record? Because I may not have captured each and every word.
If they can make a copy, they can supply a copy to the court of what they have said.
Yeah, let's find out.
I said there were discrete attempts.
We have a right to respond to the speech.
Give information to the court on national security matter, and I stand by that because national security matters cannot be written and cannot be said in public. And if it is a matter of national security, all three arms of government collapse into one, and it can be related.
All right, I didn't hear. I think then Mr. Abi is correct.
She has agreed, my Lord. You know, she was reading, I was listening.
An attempt, you didn't.
Yeah, it was an attempt. An attempt is as serious as a committed action. So, my Lord, permit me to finish. I'll be very short.
Yeah, proceed.
Yes. So the second fundamental issue I picked from written speech which she read, the submission, was that the heavy matters of national security demanded the presence of Mr. Gilbert Masengeli there, as opposed to what was otherwise personal tribulations that he was to meet in court. And my Lord, this background is important. It is important for this reason. Lord, very early in the morning, we heard of reports published by none other than the President of the Law Society of Kenya, Madam Faith Moni Odhiambo, that the three petitioners had been released and dumped somewhere in Russia. There is a background to it. Just be patient.
They have been released. No, I'm from court. I'm not able to see what is happening.
Yes.
What are you saying?
If you could just be patient, you'll get to hear what I'm saying. So, my Lord, it was our expectation today that the respondents will come and say, and we still expect them to say, that the first order for habeas corpus has been complied by us, and here before the court are the three. Relax. And if at all they have complied with the habeas corpus and produced the three, then this litigation will come to a natural end. So we'll be happy if we'll be told that is the case, because we've just seen this reports. Number two, my Lord, on the substance. Subsequent to the conviction and the sentence, Mr. Gilbert Masengeli approached the Court of Appeal on two civil applications.
Approached the Court of Appeal?
Yes, on two criminal applications. One is Nairobi criminal application number E466.
Criminal application number
466. My Lord, if you could kindly ask them to be quiet, because I need to make these submissions in quietness.
Yes, let's maintain silence.
Yeah, it's not parliament or a public rally.
Yes, proceed.
Yeah, the first is criminal application number E466 of 2024. Mm-hmm. This criminal application seeks, in the main, to stay the order convicting Gilbert Masengeli of contempt of court. Number two, before the Court of Appeal, is criminal application number E471 of 2024. In this second criminal application, Gilbert Masengeli and the rest of the team have sought an order before the Court of Appeal to suspend and stay the sentence made by this court upon conviction. My Lord, indeed, these two applications were before the Court of Appeal yesterday. And they have been, the Court of Appeal on Wednesday, the day before yesterday. And they have now been rescheduled for hearing next week, for a date that will be given by the President of the Court of Appeal. So, my Lord, the derivative from the developments at the Court of Appeal are this: that the Court of Appeal is now seized of the twin question of the conviction of Gilbert Masengeli and the sentencing of Gilbert Masengeli. And for that reason, Lord, the jurisdiction that this court had can only await the Court of Appeal's decision on those 2 applications. Further, my lord, those developments before the Court of Appeal have an impact on the suspended nature of the sentence this court meted on Gilbert Masengeli. The nature of that suspended sentence is therefore before the Court of Appeal. So, my lord, with those circumstances, this court can only do 2 things. One is to hear from Gilbert Masengeli on how he has complied with the order for habeas corpus, because he's here. And if he has complied, as we have read, then of necessity, these proceedings must terminate. Or if they don't terminate, then they must be held in abeyance, awaiting the outcome of the challenge against the order for conviction and the order of sentencing. That, my lord, in my humble submission, is what should happen today. I don't know whether any of my colleagues would like to speak.
No, from the petitioner side. Okay. Let's get a rejoinder from.
My lord, the Vice President of the Law Society is here.
All right.
Let me put him on record first, and of necessity, he must speak. Just to say he has something, or if he doesn't have anything, then we'll say as much.
Your name?
I must abide by.
Okay, say something.
My Lord, the President Emeritus having a summary is what we have to say. Just for record, I was attending the admission of advocates, that is why I did not come in time. But as a law society, we are eager to see this matter concluded to its logical conclusion in the procedure and the framework that this court deems fit with the nature and the weight in our petition. That is all, my Lord.
My Lord, with your kind permission, the summary of what the Law Society of Kenya is saying is that this court is functional sufficient. It's already concluded this matter. It is pending before the Court of Appeal. And the moment it goes to Court of Appeal, the jurisdiction changes, and the matter at the Court of Appeal has to be dispensed with first before the proceedings here go on. My Lord, the last one is that the issue of conduct of court has now been personalized between the judge and the convictee. And therefore, the convicted person has to comply first before they have audience of this court. They have to show that they have obeyed the court, then the court can hear them. I thank you, my Lord.
Mr. Miller.
Yes, my Lord, a brief reply. The one thing that we must take into account is the orders that this court gave on the 13th of September. The orders, my Lord, had a rider. And the rider was that Mr. Masengeli could avoid sentence if he appeared before this court within a period of 7 days. My Lord, the court defined the order as a coercive order. My Lord, this court's order is still in existence. The 7 days have not expired. We actually moved the court yesterday before the presiding judge. And we were ready to produce Mr. Masengeli even yesterday. It is the presiding judge who directed that we mention the matter before you for production in compliance with the orders of this court of the 13th of September. My Lord, the Court of Appeal matters in question that have been referred to by my learned colleague do not have, or first of all, are not heard on the basis of the fact that the petitioners who are respondents therein were not ready to proceed. And as a result of that, my Lord, no orders were granted by the Court of Appeal. As it is right now, my Lord, the matters in the Court of Appeal do not even have a date. To go the way the Law Society petitioner herein are suggesting to this court would be a gross violation for the first respondent's constitutional rights to a fair hearing. My Lord, you're still seized with jurisdiction as per the order you granted on the 13th of September. Your order is still alive. It has a compliance clause, and that's why Mr. Masengeli is here. And therefore, my Lord, to say that the matter is terminated is premature and a misconstruction of the order of this court of the 13th of September. Most importantly, my Lord, the petitioner's counsel, Senior Counsel Harvey, has indicated in his submissions to this court that the missing petitioners have been found. My Lord, surely the fair thing to do now would be to allow Mr. Masengeli to take the stand as you directed, to explain the circumstances as per your ruling, and most importantly, my Lord, to deny him that opportunity on the basis of the submissions of the petitioner in the face of the admission that the missing persons are alive and well would be a gross miscarriage of justice, my lord. We'd be sending him to prison for nothing. I therefore pray that you allow us to put Mr. Masengeli on the stand in keeping with your order of the 13th of September, which has not been varied, set aside or stayed by any court, so that we can comply with the orders of this court, my lord. That's all.
My lord, permit me to distinguish the application at the Court of Appeal as against the proceedings before this honorable court. It's disturbing that we appear to be approbating and reprobating the jurisdiction of this court. Is there an order injuncting these proceedings? No. Does the court have the power and authority to entertain today's proceedings? The short and straightforward answer is yes. The application at the Court of Appeal is only one. Mr. Masengeli has filed only one application and no appeal yet. That is application number E7471 of 2024. He seeks to overturn or to stay the conviction, but would be happy to be guided if these proceedings can discharge the conviction. My lord, our understanding of these proceedings and the orders are clear. This being a court of record and a court of sequence, this is the sequential order that the court directed. Number one, a sentence be and is hereby imposed of 6 months. Number two, that sentence be and is hereby suspended for a period of 7 days. On condition that the contemnor within the permitted period appears before this honorable court, which he has done, apologizes, which is why my learned senior Mr. Miller is saying that it should be sworn in so that he can adopt his statement and apologize, and then purge that content, in which case the court would exercise its discretion to release him ex debito justitia, having explained himself and having been pardoned, therefore free to go. My lord, the direction that command itself at this stage is that by the presence of the contemnor here in court, and yesterday, what follows that, sequentially, my lord, he ought to be sworn in. Out of abundance of caution, my lord, Mr. Masengeli has filed an affidavit, which is on record, dated 20th September 2024, containing documentary and evidentiary material that he intends to rely on together with his own statement to improve
the credibility and the cogency of his apology, we do plead and pray that the court down directs that Mr. Masengeli here is present be sworn in.
Just a minute. I've not made just a minute. I've not made a decision. You will allow me. You have made submissions and you're already asking your client to get to the witness box. Sorry? Now, I don't want the back and forth, because if we continue like this, we will not end these proceedings.
Yes.
I thought I'd given the Law Society an opportunity to speak.
Yes, my lord.
And what Mr. Miller and Mr. Owola were doing was a rejoinder. Isn't it?
Correct, ma'am.
So why don't you then allow me to make a decision?
Yes.
Isn't that the order of things?
That's it, my lord.
Yeah.
It's only that they introduced some new facts.
Which one?
The affidavit. That was fact that we just learned about the affidavit.
It was not served.
Yes, it was served.
Was it served?
It was served. Though
When?
You can leave it at that.
When was it served?
My lord, for purpose of this ruling, let me just go.
Yes. Let me just make a decision on this. Then.
Just for the record, we served and an affidavit. We served the affidavit.
But you will understand that when in a proceedings of this nature, when one is summoned before the court, you not just rely on documents, because the court will also want to observe the demeanor of that particular person.
Yes, my lord. Yes. And that's why he's here, my lord.
So it's not a question of filing documents. It's a question of complying with the order for the court to find out exactly what was happening from the person. But the issue here is whether or not I should allow Mr. Masengeli to explain to the court why he has been deliberately defiant in disobeying the summons of this court.
my lord, enrich the record. Mr. General has joined us.
Leaving Mr. Harvey.
Yes.
Is it good?
Who?
He's come to leave Mr. Harvey.
You should be this side.
Okay. The acting inspector. So who has joined us, Mr. Harvey? The Solicitor General. All right. Thank you. Welcome.
It comes immediately after the Attorney General.
this is the decision of the court. The issue before me, or before the court, is whether I should allow Mr. Masengeli, the contemner who is before the court, to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed that he has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of the habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus officio, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Ogola, who have argued that the court gave a coercive order which end compliance requirements. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make a reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Okay, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach in which it includes what is known as the purging conditions. The coercive approach gives the contemner the opportunity to save himself from punishment, the equivalent of purgatory in religious circles, so that if the contemner complies and fulfills the obligation required of him by the court can weigh and consider whether he has cleansed himself of the original sin. In my ruling on the 13th of September 2024, I had this in mind when I included condition number 4, which stated as follows: the court nevertheless considers it desirable to impose a coercive order as opposed to the punitive order. In this regard, Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend the sentence for 7 days only. The acting Inspector General can redeem himself by availing himself before the court in person to answer to the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. Having stated as much, and the contemner having availed himself before the court before the lapse of the 7 days, I would be going against my own orders if I deny him audience as urged by the LSK. This is a court of justice and must act fairly at all times towards those that appear before it. Mr. Masengeli is entitled to be heard by virtue of this court order. The Court of Appeal has not taken away the jurisdiction of this court, for it has not issued any order being barring this court from hearing Mr. Masengeli. This court is not functus official either, as the sentence was not purely punitive but coercive, laced with purge conditions that the court reserved to consider before the sentence becomes effective. I will thus allow Mr. Masengeli to take to the stand and redeem himself.
My Lord, can you give directions on each side?
He must be on the dock.
My Lord.
Yes.
Purely on procedural matters.
Yes.
And stemming from the natural rights and challenge the testimony.
Yes.
The petitioners reserved the right to cross-examine.
My Lord, with your kind permission, this is a matter between the court and the contemnor, and it is strike law that the petitioners have no right to cross-examine.
Okay, let the order.
Sorry, that cannot be the premise. Because if he's just a minute, I have a right to that. If he insists we ought not to be here,
Yes.
we may as well walk out.
Okay, let me do this. Mr. Harvey, kindly listen. Let him explain. Immediately he has done that, I will seek submissions from you on whatever issue you want, then I will rule on it. But for now, let's just follow the order. Let's hear him.
My colleague has practically made
Yes. Yes.
It is taking oath from the Bible. We will reserve our right to cross-examine.
You will reserve the right to cross-examine, but let's first hear him. Then we can see whether it is necessary for you to cross-examine. Because you see, why do you make the decision to cross-examine before you have even heard what he says?
Precisely, madam.
No, a prudent lawyer
No,
must
just wait. Just wait.
convey to the court what he intends to do.
Yeah, just wait until he does it, then we will consider.
My Lord, may I seek your leave?
Yes?
May I seek your leave to leave the court?
Very well, thank
Mr. Mutinda and Mr. Bita
It's okay.
will appear. Thank you so much.
Okay, Annette, swear the witness. Swear him.
So you repeat after me. I swear by the name of the Almighty God.
I swear by the name of Almighty God.
I swear by the name of the Almighty God.
I swear by the name of Almighty God
That the evidence I shall give.
that the evidence I shall give
Touching the matter in question.
touching the matter in question
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
You can start with your full name.
Kindly tell the court your full name, please.
My name, Gilbert Masengeli. Deputy Inspector General of Administration Police.
Can you tell the court the specific roles or role that you have been serving within the Inspectorate of Police?
My Lord, some of my duties and responsibilities is border security, ensuring that our borders are safe from incursion within and without for the safety of the Kenyan youth, my Lord.
Now, you have sworn an affidavit dated the 20th day of September 2024, which is here. Is that correct?
Yes, my lord.
Affidavit dated
20th of September 2024.
You've not been served with this affidavit.
It's been forwarded to Rebecca's phone 5 minutes ago. So, don't expect to read an affidavit phone.
Would it assist if I gave you time to go through the affidavit? Because I can adjourn briefly so that you go through it, if that is what you want. Because basically what he's trying to say is he's going to rely on some of the information in the affidavit. Is it possible for me to allow you to go through that affidavit? I have a copy. I have a copy here, but I would, if you don't mind, I could ask my court assistant to have it photocopied by the court.
Hello, there is a return of service.
No, let's not get to that. We just want to do things in the right way. Yeah. Yeah, I just wanted them to get a copy. Mr. Nelson Avi, I want us to agree. Can I adjourn for 20 minutes so that you can, maybe 20 or 30 minutes if you wish?
I think 20. Even 15 would be good.
Very well. So in So let's, from good order, let's adjourn for 20 minutes. We allow the petitioners to peruse the affidavit, and then we can proceed after that. I think it's important that we proceed when we are on the same wavelength. Yeah. Kindly let's adjourn and.
the petitioners are quick to join us. My Lord, my learned seniors have fallen into a grave error. It was not a must that they put the container on the dock. To lift a Bible and allege to speak the truth. Not conflict of the Constitution.
And only to add, my Lord, that your order of 13th of September 2024 is very clear. And therefore, my Lord, the contemno is in court in compliance with that order. And I would urge, my Lord, that he responds to the orders that were issued by yourself, which, my Lord, did not again quote for any responses or any. So we submit, my Lord, that the contemno obliges to the orders that were issued by this honorable court. Much obliged, my Lord.
My Lord, if you may allow the petitioners a quick rejoinder. My Lord, my learned seniors have fallen into a grave error. It was not a must that they put the container on the dock. To lift a Bible and allege to speak the truth. He could as well have spoken from where he sits and stated to the court what he wants to say. But now that he has taken oath, the natural right to be heard is henceforth invoked. Among the constituents of the natural right to be heard, Your Lordship, which is also preserved in Article 50 of the Constitution, is the right to challenge evidence that has been adduced. They are going to adopt an affidavit. An affidavit is a way of adducing evidence before court. Your Lordship, that evidence cannot go unchallenged. It is a natural right to be heard. The petitioners have a right which is inalienable to challenge the evidence that the deponent is going to allude before this court. And if possible,
point out perjury. Your Lordship, we reiterate our right to cross-examine the consumer. We are much obliged.
The contemnor has come before the court to purge the contempt. He seeks to rely on affidavit evidence and has also been sworn. The petitioners are present in these proceedings and seek to cross-examine him on the contents of the affidavit, where the court is only supposed to hear the contemner as it be brief, where the court is only supposed to hear the contemner as he punches the content. I have considered that the petitioner have not had a chance to respond to that affidavit presented, and therefore giving them the right to cross-examine is a way of ensuring their participation in the proceedings, however nominal. However, these proceedings are not a trial. A request to cross-examine the contemner for 40 minutes is too long and cannot be allowed. I shall assign only 15 minutes. After the contemner is done, each side will have 5 minutes each for a very brief submission.
Thank you, my lord.
Much obliged.
So, Mr. Miller, you can proceed.
Thank you, my lord. So do you wish to adopt the contents of your affidavit?
Yes, my lord.
Now, just look at paragraph 2 of your affidavit. You are convicted for what in particular? What was it that led to the conviction?
Contempt of court, my lord.
For failing to do what?
For failing to comply with court habeas corpus dated to that August 2024, my lord.
Okay. And that was an order to present in court.
Yes, my lord.
Petition number 2, 3, and 4.
Yes, my lord.
Okay. Now, let's go to paragraph 16. The matter came up for mention on 26th of August 2024. Where were you on the 26th of August 2024?
My lord, on that particular day I was in Coast Province. I was in Mombasa, Lamu, and Boni Enclave, my lord.
Okay. Now, look at paragraph 18. You are supposed to appear in court on the 29th of August, 2024. Paragraph 18.
Yes, my lord.
Can you tell the court where you are on the 29th of August, 2024?
I was at Mpeketoni and the Boni Enclave as at large, those areas of Kuluko, my lord.
Okay. On the 3rd of September 2024, did you send a representative to court?
Yes, my lord.
Who did you send?
My representative, my legal, Mr. Otiende, my lord.
Okay. And where were you on the 3rd of September 2024?
On that very day, my lord, I was still on those borders of Kenya-Somalia border, the Shakani and Boni Enclave.
Okay. Let's go to paragraph 21. were you on the 4th of September 2024?
On this particular day, my Lord, I was en route to the northern Kenya, part of Kenya, my Lord.
Then you were supposed to attend court on the 5th of September 2024. That's paragraph 22. Where were you on the 5th of September 2024?
On this particular date, my Lord, I was in Mandera, that is northeastern region, and I had also sent my director legal, Mr. Otiende, to represent me, my Lord.
Now, on the 9th of September, you were supposed to be in court personally. Can you tell this court where you were? Paragraph 24.
My Lord, still on this date, I was still in northeastern and particularly in Wajir. On this date, I was still in northeastern and particularly in Wajir, those areas of Huluko, Korfarar, and Konton, my Lord.
Huluko?
Huluko, Korfarar, Konton, Korfarar.
Hulugo, and where else?
And Karsa.
That is paragraph 24. Just a minute.
My Lord, may I proceed?
I just want them to see those areas. You said paragraph 24 of the affidavit.
We're referring to paragraph 24 and 25.
Those areas are not mentioned.
Yes. Yes, but he was meant to be in court, my Lord.
Wait, he is on oath anyway.
Yes, he's on oath and he was meant. Yes. Yes, but he was meant to be in court, my Lord.
Wait, he is on oath anyway.
Yes, he's on oath and he was meant to be in court.
So the last area is Hulugo, Korofan, and where else?
Karsa, my Lord. Those are FOBs, the forward operating bases for the officers in the northeastern, my Lord.
All right.
When you were meant to be in court, can you indicate to the court where you are then? On the 14th of September 2024?
On that very day, my Lord, I was still on my way now downwards because from Wajir we had to come back to those sides of Karisa, and in Karisa we had to traverse to those forward operating phases of our officers like in Welmerer and Afi, my Lord.
Now, was your failure to come to court deliberate or a deliberate act of lack of respect for the court?
My Lord, it was not a deliberate failure because I had also requested my assistant to come and represent me and the legal officer to do the same, my Lord.
Now, this petition relates to missing persons who are petitioner and for Bob Njagi, Jamil Longton, and Aslam Longton.
Yes, my Lord.
Aslam Longton.
Yes, my Lord.
Have they been in police custody at all?
My Lord, they have not been in police custody, and I just learned this morning from Honorable Harvey that they've been found, my Lord.
So you learned from who that they've been found?
From President retired Emeritus LSK Harvey.
Let's have silence. So you learned from who?
I learned from the Emeritus LSK President Harvey.
My Lord, he said honorable. I don't want
So, sorry, just a minute. I just want to capture what you are saying. You learned that those people have been what?
I learned that those people have been found from Harvey.
Have been what?
I learned that those people have been found from Harvey.
Okay, or this morning?
This morning.
All right, thank you.
And how did you learn? Where did he say?
He said it before this court, my Lord.
Okay. Did he describe the condition in which they are?
I did not get it clear, my Lord.
Okay. So, now that we are here.
Just a minute, Mr. Miller, because now that is coming from him, what he has heard from Mr. Harvey.
Yes.
Mr. Harvey, is that factual, what you told the court? Is it factual?
My Lord, I will cross-examine him. Did not get this evidence.
I just wanted, yes, let me find out because...
Yes, it's true.
All right.
I stated in court that there are reports that have been released.
All right.
The report was made by the President of the Law Society.
All right, thank you. I think that's
to
enough.
alarm everybody that the President of the Law Society opinion knows that these people are released.
All right.
And then,
all right, proceed.
My Lord, perhaps you can also tell the court the condition in which they were?
No. Miller, proceed.
Thank you, my Lord. Now that we are in this situation, what would you like to tell the court?
My Lord, I want to thank you for the opportunity you accorded me to stand. I want to thank you for the opportunity you accorded me to stand before you. Before I say anything, my Lord, I would like to apologize to the Lordship and the judiciary for the events that have transpired leading to the orders of this court. My Lord, I respect you and you too to uphold the rule of law. As a police officer, it is my duty to enforce court orders and ensure that court orders are obeyed. My Lord, I pray, my Lord, accept my apology, vacates conviction and sentence. So I pray, my Lord.
Okay.
That's all, my Lord.
From the respondent side, would any one of you have any question for the Inspector General?
My Lord, I was asked to hold Mr. Kiara's brief.
Mr. Bitter, do you have any questions for him?
No, I just want to be ambassador.
So, Mr. Bitter,
I'm holding Mr. Kiara's brief for the fifth response.
this is a courtroom. We would want everybody to be satisfied with these proceedings. From the respondent side, does any one of you have any question for the Inspector General?
I'm already satisfied, I think.
All right.
I think there is any questions from my side.
Right. Mr.
We are satisfied.
Thank you so much. So, Mr. Kitonga Murugara. Solicitor General, Mr. Shantak. Now, Mr. Nelson Avi, you have strictly 15 minutes, which you must utilize well.
My Lord, I will take less than 5.
My court assistant will keep time.
These three Kenyans, Bob, Michelle, Jackie, Jamil Longton, and Aslam Longton. Do you know them?
I don't know them, my lord.
When did you come to hear of it?
I heard of them when it was reported at Kitengela, and the signal was circulated by the OCS to all OCS in Kenya of the missing person, my lord.
How long ago was that?
The date you've mentioned, my lord.
How long ago was that?
The date you've mentioned, my lord.
Pardon?
The date you've just mentioned, my lord. That was on the 19th August, my lord.
19th of August.
Yes. Around 1 month, my lord.
Around 1 month.
Around 1 month, my lord.
Around 1 month. What efforts, if any, have been made by the National Police Service to trace this thing?
My lord, immediately it was reported, the signal was sent throughout the country to all, opened and started immediately, and still is live. The investigation is on. Just we appealed to the public also to assist us on where they could be found, my lord.
You have any report?
Us on where they could be found, my lord.
You have any report, preliminary or final, so far as those investigations are concerned?
Come again, my lord.
Do you have any report, preliminary or final, insofar as the investigations are concerned?
What I know, my lord, is that the investigation is still on, and they've not been found. As this morning when I was coming to this court, my lord.
When did you wake up this morning?
Wow, a bit early, my lord. It was at 0.
Okay. So when did you set off to come to this court?
My lord, I came to this court very early because I was supposed to start at 9, and by 8 I was here, my lord.
No, Masengeli. I can speak in Kipukutu if you want. My question is, when did you set off to come?
Set off from where, my lord?
Wherever you are.
At 0800, I set off from my office, headed to Milimani Courts, my lord.
By then, had you received the briefings insofar as these three are concerned?
My lord, I received the briefings that they had not yet been found. That was the brief that I had received because there was no new brief that I had gotten from the legal. But if there has been from here, I will go and confirm from our police stations if any has been made a report, my lord.
So have not complied with the habeas corpus order to produce it?
My lord, we did not have them in our custody, my lord.
Now listen, don't answer the question, answer my question. Now listen, don't answer the question, answer my question. There was an order directed at you to produce these three. So have you complied with the order? You can say yes or no, and if you say no, then you explain why you're not. You, please, get out of that place. My lord, this gentleman, the short gentleman, is giving the tall gentleman answers.
My Lord, I was standing next to him, and nothing of that sort is happening.
You know, they have taken us through a charade. We will not be touched with this nonsense. My Lord, I request that these people move away from the witness. Miller can remain, but these individuals can move away.
Yes, I do. Okay.
Yeah, and I'll be brief. I want to ask the last question. Mr. Masengeli, look at the court, listen to my question and give the answer. There was an order directed at you to produce these three in court. You're aware of that order?
I'm aware, my Lord.
Have you produced these three in court?
I've not, my Lord, because...
It's okay. You have not produced them in court.
Yes, my Lord.
Why?
I don't have them, my Lord. And they are not within the police cells, my Lord.
Okay. That's a sufficient answer. Thank you so much, Mr. Gilbert. That's all for me.
Sawa.
Kabisa, ngoja kidogo. Kuuliza maswali.
I have very few questions as usual, my Lord. Yes. Good afternoon.
Good afternoon, my Lord.
I have very few questions for you. When you took office, did you swear to protect the rule of law?
Yes, my Lord.
Do you think you're above the law?
No, my Lord.
Do you think your conduct allows you to continue holding public office?
Yes, my Lord.
The conduct of not obeying the rule of law allows you to hold office.
Here I am, my Lord. I have obeyed.
That is it from me. Silence.
My Lord, I have two questions. Witness. My name is Manuel Jose. Yes. Mr. Masengeli.
Yes, my Lord.
Do you find it difficult that the day you chose to come to court today is the same day that the three petitioners have been found? Do you find it disturbing as an acting inspector general, a former acting inspector general, and currently a deputy inspector general?
My Lord, that is subject to investigation. As police officers, we will have to go further and investigate. Also have a...
My question was very rhetorical. Do you look at the coincidence between the day you've chosen? I'm saying you've chosen because we have had 8 instances before here, which you chose not to come. Do you find it disturbing that the day you chose to come to court, it's the same day the 3 petitioners were found early in the morning? Do you find it disturbing?
My Lord, I don't find it disturbing because to me, up to now, I'm not aware whether they've been found.
You've answered my question. My second question, Mr. Masengeli. You have apologized to the court for not honoring those 7 summons. Is that an admission of guilt from your part?
My Lord, that's not an admission of guilt, but I explained myself, my Lord.
Why did you apologize? If, truthfully, your affidavit, the one you have supplied to the court, if whatever you have sworn and presented to the court is true, why are you apologizing for doing the right thing?
Because, my Lord, I was supposed to be here in person.
You're supposed to be here in person.
And here I am, my Lord.
Your apologies to you being here in person, not to your conduct of disobedience. It's a straightforward.
My apology is to pray that the Lord of this court accepts the apology that I had just made vacate the conviction and the sentence. So I prayed to my Lord.
To say that you've confirmed to this court that you are guilty and the court convicted you because of that apology and the sentence?
No, my Lord.
Lastly, my last question is on the orders. From the time this petition was filed by the Law Society of Kenya, at what point did you see the first order of this court? Or come across the first order summoning?
My Lord,
My Lord, why don't we tell you we are against this we are allegedly using courtly language. But look, they're all combined there. Can the witness answer?
Unless we agree that they are adopting their fidelity. That's correct, man. Listen, we agree that they are adopting their fidelity. Unless they are showing the witness, let's only allow Mr. Miller to do it, not any other.
You know, my Lord, you're opening a big door for them, huh? Just
No.
be firm.
No,
Then the advocate should be there.
the 9th of August.
29th of August.
There are 5 people asking him to do
Where are the court of
for the dates might not be You can decide. Why are you negotiating?
Get them out. Leave Mr. Miller only. Those are the directions of the court.
My Lord, I appear with Steve Ogola.
Or Mr. Steve Ogola can do.
Yes, and I also appear with Juma
I don't want any here. We only have Mr. Ogola and Mr.
He's my legal officer.
Would you please step? Move a bit. Move a bit.
My Lord, that's legal officer.
And you've been getting on the first order. I appreciate that. It's no big deal.
Let's have you and Mr. Ogola. That's okay. Yes, let the other officer stand there. Let the officer stand there. Yes. The officer, you can stand there so that you can shoot the case. Yes, Your Honor. Mr. Ogola and Mr. Miller, you are free now to direct your client to whatever portion of the approach.
Thank you, my Lord.
To answer the question, my Lord, it was on 29th of August 2024, my Lord.
29th of August.
2024, my Lord.
Was held when these directions were being given, so that I don't repeat to my life conditions.
You said it was on 29th of August.
Yes, my Lord.
That was the first time you knew that there was an order summoning you to court.
Yes, my Lord.
Were you aware of the second order? It's a yes or no?
My Lord, I've put it in my affidavit.
That is why I'm asking you that question. Were you aware of the second order? You can say yes or no. This is a question.
Yes, my Lord.
You're aware of the third order?
Yes, my Lord.
You're aware of the fourth order? So yes or no?
Yes, my Lord.
You're aware of the fifth order?
My Lord, I think you need to clarify them in terms of dates. My Lord, it is not too sure of the dates of the orders. Let him just abandon that line of questioning.
My Lord, the witness has already answered. I don't think Malalim Senior is doing the right thing by countermanding the answer from the ground. You had the benefit of having all the 8 orders on your desk. Will I be right if I say that? Mr. Masengeli?
No, my lord.
So if you didn't have the benefit, how did you find yourself in court today?
Because, my lord, I got the conviction and the last orders that I appear in person, my lord.
So are you trying to tell the court that you were only aware of the first order and the conviction and sentence? Is that your position?
No, my lord.
Well, that's all for me.
How many minutes to win?
Also, we are quoted, we don't need to remember everything. The court knows that. And so it doesn't need to prove a point.
My court assistant tells me that that confusion has only spent 3 minutes. So you are 3 minutes.
10 and 10, it's fine. Very good, I'll proceed. Looking at your affidavit.
Your name, thank you.
My name is Abubakar. Mr. Masengeli, good afternoon.
Good afternoon, my lord.
You didn't mention the areas you were during when the orders were issued, but you mentioned you were in Lamu County. Which other county?
Northeastern, my lord.
Northeastern region.
And Eastern, my lord.
Northeastern, yeah.
Northeastern, Eastern, and the Coast Province, or Coast Region, my lord. Those 3 regions.
Very good. From the evidence, where do we see that you are indeed there?
I filed in my affidavit, my lord, and there are signals attached on the same, my lord.
The directors to one, that where are you in Lamu?
I said on oath.
Please, directors, please. In the affidavit. Mr. Masengeli in Lamu. Mr. Masengeli in Northeastern. In the affidavit, please.
24?
Yeah, so we didn't need to accept them. Why the necessary? No.
21?
Yeah. Okay, number 18. From page 23. Yeah, GM2. 23, 24.
My lord, in my affidavit, my lord, on number 23, paragraph 23, my lord, and paragraph 24, my lord.
Yes. Yes, I've read the...
And 27.
And paragraph 27, my lord.
My question is, substantiate that. Cogent evidence that I'm in Lamu.
Ask him to
How did you get that? Did you fly? Was there
ask him to peruse that. That's just...
My lord, you may peruse the extra?
Yeah.
Let him peruse the...
How did you get to Lamu? How did you get to Lamu? Mr. Masengeli?
My lord.
My lord, just today, since the affidavit has annexures, and the witness has already pointed out the paragraphs that have the annexures, annexing the signals that counsel is asking, wouldn't that be sufficient?
Another 1 minute. Okay, Mr. Masengeli, how did you get to Lamu before?
My lord, I think also we need to also be very careful about this line of questioning. This is a very senior state officer. There are issues of... No, my lord, let me finish.
My lord.
Let me say this. You see, this is cross-examination. When the witness says that he has answered, If you are not satisfied with the answer, you can only now, if he is not able to go beyond what you are probing, then you can only make submissions on that at a later point. But you cannot keep on asking him to do to substantiate.
How did you get to Lamu, Mr. Masengeli?
My Lord, I used the police chopper.
Wow. Why didn't you use the same chopper in the 5 times you were summoned to court? That's minutes, right?
My Lord, there are 4 mentions, not 8.
Sorry? 4 mentions. Okay, why did you use the chopper at the first mention? The second mention? The third mention? The fourth?
My Lord,
you admit to breaking the court orders despite the chopper, right?
I cannot disobey court orders, my Lord. Court orders are there to be obeyed and enforced, my Lord.
On these 4 mentions that you say, though you believe there are more, you sent someone, correct?
Yes, my Lord.
You sent the director liquor, you sent the deputy IG. Under Section 8, you have the power to delegate, correct?
Not only powers to delegate, my Lord.
Yes or no, correct?
Yes, my Lord.
Why didn't you delegate to Lamu? Why didn't you delegate to the Northeastern?
My Lord, I am the head of that unit that was engaged in.
The question is why?
Security operations, my Lord, calls for my being there guidance because I know I have the commanders across the country, my Lord. And with what had happened there, I hate to
But you agree you can't be angry all the time.
It's a fact, my Lord.
Yes. So you delegate sometimes, correct?
Sure, my Lord.
Yes. So you had the ability to delegate. I leave it at that, my Lord.
Very well. So we are done with, you have exhausted your 15 minutes. You have exhausted your 15 minutes. Any re-examination? Re-examination from any re-examination?
None, my Lord. Just one question. Just one question, my Lord. I'm so sorry.
No.
Yes, I'm so sorry. I just realized there was something of importance.
No, you said no.
You delegate security operations, you said no.
Yes.
My Lord, I have just one question.
No, you said no, Council.
Allows the law society to communicate as well with doing that. In terms of the state of affairs.
My Lord, is that procedural?
It is an observation as a law society.
Okay, just a minute, Council. I understand that I'll give each of you, Mr. Miller and the petitioners, 5 minutes to make brief submissions because after this I want to go and write a ruling. You've heard what the Inspector General of Police has said. You've heard what he has said on cross-examination. So make very brief submissions so that I can now come up with a ruling and we can see now the way forward.
Yes, yes.
So, yeah? Yes, so the IG is done, you can now leave the talk. So I will allow who comes first. Yes, Mr. Wolf. You only have 65 minutes to make your brief submissions. If you can make it in 2 minutes, well and good.
A lot of the question that calls for examination is whether the past president has indeed complied with the Honorable Court order dated 13 September 2024. In particular, Directive number 4. One of the short and straightforward answer is a resounding yes. The then acting Inspector General of Police, Mr. Gilbert Masengeli, has presented himself before this court pursuant to that directive. The second issue, my lord, having so presented himself, has Mr. Masengeli purged contempt? My lord, our simple and straightforward answer is a resounding yes. We say so because the Honorable Court found Mr. Masengeli to be in contempt in the first instance for failing to comply with the habeas corpus orders dated 23rd August 2023. To that limited extent, my lord, Mr. Masengeli has clarified to this honorable court that the reason for non-compliance is that he did not have the second to fourth petitioners in his custody. It bears mentioning, my lord, that the first petitioner, without being moved by anyone, has in fact conceded to the Honorable Court that indeed Mr. Masengeli did not have the second to fourth respondents in his custody. The Law Society of Kenya says the second to fourth petitioners were released early morning. We have followed the proceedings. We have not had an allegation, and thank you, the LSK, that they were released from police custody. So therefore, I believe that limb of explains what I can only consider as the unhealthy tension between two competing constitutional obligations. Mr. Masengeli has clarified that his absence from this court was not in any way intended to demean the dignity and authority of this honorable court. Therefore, insofar as the second limb of that order, first limb is to appear, the second limb is to explain the non-compliance, my lord, we submit very humbly that the court finds favor with our submission that that limb has been satisfactorily explained or achieved. The third issue that then commends itself for consideration by this court is whether in an attempt to explain the third issue that commends itself for consideration is whether in an attempt to explain non-compliance with court orders, Mr. Masengeli has shown remorsefulness. Simply put, is Mr. Masengeli sorry that he failed to honor court summons? Has he apologized? We submit, my lord, that that answer is evident from Mr. Masengeli's own testimony in chief. He has profusely apologized. He has restated his respect for the dignity and authority of this court, and he has pleaded for mercy. As the Honorable Court rightly said, these proceedings are only second to what the Christian doctrinal teachings call purgatory. That if you accept, as the Bible says, that you have fallen short of the glory of God, and you repent and return, the Lord shall show you mercy. Mr. Masengeli pleads with this court that he benefits from this court's grace in accordance with the court's inherent discretionary power to forgive. The court has the power to punish. The court has the power to forgive. The court has punished. He now pleads that the court forgives. The court has punished. He now pleads that the court forgives. Lastly, what are the orders that commend themselves? The orders that commend themselves, yes, is the vacation of those orders of conviction and sentence, my Lord, thank you. And this, the orders that I need the 1 minute so that when you come to our time, we can also enjoy. What are the orders that commend themselves, my Lord? Having had the apology of Mr. Masengeli, he has pleaded with this honorable court that this honorable court do discharge the orders of 9 September 2024 that convicts him of contempt of court. And lastly, that the honorable court be pleased to extend grace and discharge the orders dated 13th September 2024 insofar as they relate to custodial sentencing. We thank you, my Lord, for indulging Mr. Masengeli, and we will be requesting on behalf of the first respondent, because he still are serving police officers under the command and the authority of the Attorney General, that the Solicitor General would probably have the last word on our part. Thank you, my Lord.
Thank you, my Lord. And I'm sure the Law Society will just give me an indulgence. Just one or two things, my Lord. It will be the greatest humility that Mr. Masengeli has submitted himself to this honorable court. He has submitted to the jurisdiction of this court. And from his own words, my Lord, if you noted, he's recognizing your Lordship. That indeed, my Lord, even what has been tendered before your Lordship is a demonstration that there was no death. He is, by appearing in court, demonstrated that as an officer, he has tremendous regard for the court. He has such a respect for the court that he is himself before this honorable court. And then Mr. Masengeli, my Lord, has a career. And in the discharge and expeditious obligation as a career police officer who has risen through the ranks to be the DIG administration, and having been granted the opportunity to act, my Lord clearly tells us that he is an officer who has always complied, and he has stated this. And therefore, that's why my Lord will submit with the greatest humility that the career of this police officers, commends to yourself, my Lord, to apply the greatest mercy in your favor so that you are able to allow Mr. Masengeli to continue serving this country. And that would urge, my Lord, the orders of 9 that led to Mr. Masengeli's conviction. Commend to yourself, my Lord, to be discharged and allow him to continue to serve. I'm sure all of us, my Lord, are enjoying the peace and the tranquility in this country because selfless police officers are taking care of our borders. And I would honorably urge my colleagues, with the President leading, and I can see Senator Manso and the rest, to also allow us for the first time to extend this to our distinguished police officer who has served with the distinction to rise to this level. Thank you, my Lord, and we would be most obliged for a favorable finding in favor of the contempt. Thank you, my Lord.
Maura Kabata. Vice President of the Law Society of Kenya. My Lord, we'll take about 10 minutes. I will spend about 7.
Ulikuwa una expect ukiambiwa ati umeshinda 50G.
And especially constitutional ones, like the one the former acting Inspector General was holding. Have to comply with the constitutional edicts. And I will not name all of them, but to be more specifically,
seat, my Lord, and as you retire, we are going to take another judgment shortly in an equally important matter. If we do not appear before you, it will not be out of sight, but we wish to thank you because these proceedings have gone on extremely well. And on behalf of the Honorable Attorney General who is not here, we have actually proceeded so well, and we thank you for that.
My Lord, just want to thank you most sincerely on behalf of all the advocates who have appeared before you. The humility with which and the manner in which, my Lord, you have handled these proceedings, we want to thank you in a very special way. We want to thank the colleagues who have come, the advocates who have submitted before you, despite the few exchanges, but in a manner that is not out of context. My Lord, we want to thank you. We also want to thank even Mr. Masengeli and all our fourth estate also for ensuring that these proceedings, my Lord, are properly recorded. We are grateful. We respect this court. And my Lord, we would forever remain grateful that you have extended to us the time to be able to canvass this matter before you, to plead the manner in which we have pleaded. And I am sure, my Lord, this ultimately is for the good of this country. And that this is a great country. I'm sure even when Honorable Manso spoke, he knows that for sure all of us cherish our country, and we want to ensure that whatever, my Lord, is done within the purview of the law. And therefore, that's why the remorselessness before you. Thank you, my Lord.
I am told that it is now some minutes past 2. I will deliver this ruling at 4 p.m. I expect the contender to be present in court.
Kuweka hii